At the outset, I'd like to acknowledge that we are on the land here today of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past and present, and I extend that respect to all Aboriginal people who are with us here today, either online or in person. We've of course got a sizable component of attendees at the launch here today who are online, and so I acknowledge that they are all on different Aboriginal lands and that those lands have never been ceded. Legal aids work really closely with First Nations people and communities, and this is highlighted in the report that's being launched here today. As such, part of our ongoing commitment to better supporting clients through the NDIS Appeals Program needs to include implementing changes to the program that increase the number of First Nations people accessing the program, and also to supporting the provision of a culturally safe environment for First Nations communities. I'd like to really warmly welcome everyone here to the launch today. I particularly recognise my fellow National Legal Aid Directors and Legal Aid CEOs, as well as representatives from the Department of Health, the National Disability Insurance Agency, and the Attorney General's Department. I particularly acknowledge, and I also thank the Department of Health representatives for their ongoing support for the NDIS Appeals Program. It's very much appreciated. Unfortunately, the Minister for Disability and the NDIS, Senator Jenny McAllister, is unable to attend the launch today. However, she has sent her very best wishes for the event. To get things going, I would now like to invite my colleague and Chair of National Legal Aid, as well as the CEO of Legal Services South Australia, Anne-Marie Lumsden, to say a few words. Thank you.
So thank you, Toby. I too would like to pay my respects to the Wurundjeri people of the Kulin Nation and pay my respects to elders past, present and emerging. I'm really pleased to be here today and part of the launch of the evaluation of the quite achieving but hugely important NDIS Appeals Program. The NDIS Appeals Program has been delivered by Legal Aid since 2016 and is one of the few truly national civil services that every legal aid has been funded to deliver. Legal aids are also the only legal providers undertaking this work across Australia, and it has never been independently evaluated until now. So given that the program is almost a decade old, it seemed timely that National Legal Aid arranged for an independent evaluation, not only to document the achievements of the program, but also to guide how we can improve our service delivery and better support our clients. And I'm pleased to say that the evaluation report clearly identifies and outlines the enormous impact the NDIS Appeals Program has in supporting people with disabilities. The report identifies the challenges for people with disabilities in navigating the appeals process and highlights the differences legal assistance makes in supporting people with disabilities to be heard. Not only that, the report also highlights the critical role the program plays through taking on complex cases to help establish the parameters of the NDIS and what should be considered when funding NDIS support plans. The program is an integral part of helping make sure that the NDIS works for everyone. And all of this has been done in the context of temporary fluctuating funding of around $5 million a year. This amount means that of the approximately 4,000 NDIS appeals matters a year, legal aids have had to limit legal representation to around 300 matters a year and legal advice to around 2,500 matters. Unfortunately, we are not able to meet demand within the available funding. And due to the changes to the NDIS made last year, demand is increasing. There's been an 88% increase in the number of NDIS appeals which have been lodged over the past 3 years. So we estimate that we would need an additional $7 million a year, or a total of $12 million a year, to meet this increasing demand – and deliver services that meet the needs of people with disabilities. In government terms, that's not a lot of money. For context, the NDIA currently spends around $50 million a year in legal services to respond to NDIS appeals. We look forward to working with the federal government as it reviews the program and its funding this year, and hope that this leads to increased and ongoing funding that can better meet the demand and continues to support people with disabilities. Before I hand over to the next speaker, I also want to acknowledge that all legal aid services, and particularly the NDIS Appeals Program, are a success because of the commitment and expertise of the legal aid staff involved. The NDIS Appeals work is specialist and it's technical and works with clients with high support needs. Legal aid staff do their utmost every day to get the best outcomes for their clients. And I would like to thank all legal aid staff across Australia who have or are working in the NDIS Appeals team for their contribution. It's very much appreciated. And I would also like to thank the New South Wales Law and Justice Foundation for undertaking the evaluation and providing such a professional report. It's great to see that this includes not only an extensive report, but an easy-to-read version of the report and a research summary. So thank you very much. I'll hand over to my Law and Justice Foundation colleague.
Thank you. Oh. Thanks. I'm Kate. I'm the Research Director at the Law and Justice Foundation of New South Wales, and I'm really delighted to be with you today to share some of the findings from this evaluation that we completed a couple of months ago. So it's lovely to see the baby birthed into the world. This work was completed by a hard-working team, and I want to acknowledge my fabulous co-authors and team members on the report, Sarah Ratcliffe, who's with us in person today, and Emily Cothey and Sandra Takchi, who are joining us online today. And the beautiful artwork that you see on the cover of this report and on the screen is called Walking to the Echo Mountain, and it's by Tom Roberts, who's an artist out of Studio 8, which is a studio for artists with disability in Sydney, and we're so delighted to have such beautiful imagery that does justice to the work. I acknowledge that we're meeting today on the lands of the Wurundjeri people and acknowledge the traditional custodians of all unceded lands. As a team of researchers committed to social justice, this evaluation was a real gift for us, and we're really grateful to National Legal Aid for bringing us on board to do this work. And I offer a huge thanks to all of the legal aid commissions and disability advocates, lawyers, and the many other professionals who took time out of incredibly busy work to be part of this study. And most importantly, I express my really heartfelt thanks to the people with disability and their families who shared their stories and wisdom as part of this evaluation. And I'm incredibly grateful to our expert panel of advisors with lived experience of disability wisdom, Margarita, Tammy and Melanie, who you'll hear from later, who really challenged us to think deeply and think differently. Over a period of 5 months, we looked at the design and the delivery of the NDIS Appeals Program legal services. We examined impacts, the context, the strengths and the challenges of the program. We sought to understand the place of legal support within the NDIS appeals process. What I'm offering today is a snapshot. It's a bit of a taster. You'll get a sense of some of the headline findings, and the slides that I'll present give voice to some powerful message that was shared with us. But I do really urge you to read the full report to get a more complete picture. So I'll start with some context. The National Disability Insurance Scheme, or the NDIS, provides funding to eligible people with disability to pay for services and supports, and that's set out in each person's individual NDIS plan. The NDIS is administered by the National Disability Insurance Agency, the NDIA. So if someone doesn't agree with a decision that the NDIA has made, such as being deemed ineligible for the NDIS or having funding in their plan cut, they can request an internal review. And if they still don't agree with that decision, they have 28 days to request a review by the Administrative Review Tribunal, and that's an NDIS appeal. The tribunal is, really importantly, different to a court. It's intended to be less formal, an environment where people can self-represent or don't necessarily need legal support. It seeks to be fair, accessible, efficient, and to support transparency. And the NDIA is mandated to act as a model litigant in tribunal dealings, and that means seeking to avoid or limit the scope of legal proceedings wherever possible. So the NDIS Appeals Program is funded by the Australian Government. It's been set up to help people through that NDIS appeals process. And there are two components. There's an advocacy component, and then there's the legal support component. And this evaluation only looked at the legal services aspect of the NDIS Appeals Program, although we did speak to lots of those disability advocates who are involved with the other element of the program. So eligible applicants must have an existing application with the tribunal, and generally the funding for legal representation is only granted where it will lead to wider community benefit or the applicant is experiencing significant disadvantage. So in this study, we drew on a range of evidence to inform the evaluation. We spoke with a representative from every legal aid commission across the country, and then in 3 sites we dove a little deeper and we spoke with people from disability advocacy services, as well as people who had accessed the legal representation part of the program. We drew together all of the existing data that we could get our hands on, and as well as things like annual reports and service data from legal aids. There's some limitations to the findings, particularly in relation to things like characteristics of clients and the nature of cases, due to inconsistencies in the data over time and the way that data is collected across the different states and territories, and that's an issue that's reflected in our recommendations. In addition to that, we systematically reviewed 118 public submissions that had been made to NDIS inquiries, and really importantly, those shared perspectives of individuals who had not been able to access legal support, as well as groups such as allied health professionals who talked about that journey of navigating the NDIS appeals process. So each legal aid commission has developed their particular service model based on factors such as staff capacity, demand, and contextual factors such as geography. The representation services have been part of the model from the outset, and they're only provided to those clients who meet that eligibility requirement around merit and disadvantage. Advice service models have really changed over time and across the different states of territories. They tend to be made available to a wider range of clients. Many legal aid commissions now have a system in place where the tribunal can book people directly in to an advice clinic, and that seems to be working really well as a way of streamlining referrals into the program. Some legal aid commissions also provide activities such as community outreach and facilitate professional development with disability advocates. So as you can see in the graph here, and as Anne-Marie mentioned in her introduction as well, the number of advice services has increased over time as the provision of advice clinics has increased and as the number of cases lodged with the tribunal has increased. That's the orange line that you can see on the slide there. The number of representation services, however, has remained pretty consistent over time, and that's the green line that you can see there. And that's because there's a ceiling on the number of clients who can access those representation services, and that ceiling has consistently been reached. There are intensive services, there's criteria that limits accessibility to those representation services, and there's a limit to the funding and the resources to support that intensive work. And you can see, for example, that in 2023-24, there were 4,068 NDIS appeals lodged, but only 356 people were approved for legal representation services. The lawyers who are working on the program see a mix of people appealing decisions about access to the NDIS, where someone's been deemed ineligible, and decisions that are about funding for supports and services. The nature of appeals tends to be responsive to changes in NDIS legislation, policy and practice. And this evaluation is particularly timely, therefore, because substantial legislative reforms to the NDIS are currently being rolled out, and this will likely have a pretty big impact, I think, on the number and types of appeals that legal aid commissions will be seeing coming through in the next few months. A key message throughout the evaluation was that everybody's case is complex, because the experience of disability is complex, the legislation is complex, and by the time people make their way to legal aid, they've already had a pretty long journey. Across all of the data, we found that the appeals process is tough, financially, emotionally, in terms of time, and not everyone will push through to the appeal stage. Those people who had accessed legal representation through the program considered themselves the lucky ones because they recognised that such legal support was limited. And the appeals process was generally viewed as something that could not be tackled alone. Well, it's always really tricky to identify who doesn't access a service. There were some groups of people that legal aid staff consistently reported that they didn't feel were accessing the program very much. Lawyers and advocates expressed concerns that they see few Aboriginal and Torres Strait Islander clients in the program. And this really reflects a larger systemic issue where Aboriginal and Torres Strait Islander peoples experience higher rates of disability than non-Indigenous peoples, but have relatively low rates of NDIS participation. People living in rural and remote areas also have lower rates of NDIS participation, and so, perhaps unsurprisingly, were not seen to be frequently accessing the NDIS Appeals Program either. While people lacking support networks might be considered those who need legal supports the most, they might also be the people who are least able to engage in or sustain an appeal or to find their way to the program. And this quote, I think we only sort of see the tip of the iceberg. Possibly the people who need our support the most don't reach us, really speaks to a lot of the feedback from people who took part in the evaluation. Despite the tribunal's aspirations for accessibility and fairness and the NDIA's requirement to act as a model litigant, people who had been through the appeals process found it incredibly difficult, complicated and tiring. While the tribunal is designed such that people can self-represent or be represented by someone they trust, it's actually experienced as very legalistic and complicated. The NDIA is generally represented at the tribunal by a legal team, and information presented at the Senate estimates showed that in 2021-22, the NDIA spent more than $41.4 million on NDIS-related legal costs, compared to $5.1 million for the NDIS Appeals Program legal services in that same year. Interview participants talked about the NDIA being lawyered up, and there was a feeling that people would be disadvantaged without having some equivalent legal support. evidence, such as medical reports, was really recognised to be important for accountable and transparent decision making. There wasn't resistance to the principle of needing evidence to support a case, but all study participants described the evidence requirements as a complicated burden that was often requiring legal support to push through. It was a reason that the program was necessary. The evidence required was often extensive, costly, and difficult to get because of its specialist nature. In contrast to people's experience of the appeals process itself, when people talked about what it was like to get legal representation via the program, they described it as a transformative point in their appeals process. And they were really quite emotional reflections when people described their relationships with their lawyer. And sometimes that was in response to the lawyer telling them difficult things, but they nevertheless felt informed and supported. All of the study participants, and in many of the inquiry submissions, it was reported that legal support is key to being heard, and it's key to a fair and just process. Legal support is needed to level the playing field. So sometimes the advice that was provided by lawyers wasn't what people wanted to hear. That their case was not strong, that they needed more evidence, or sometimes that advice gave a person the confidence to continue their appeal. But irrespective, where people making an appeal are informed, where they're prepared, it's good for everyone, right? There are efficiency gains for the individuals, for the NDIA and the tribunal. Legal aid lawyers are also not only trying to achieve outcomes for each individual client through prioritising meritorious cases that have wide benefit, they take on cases that will test and potentially, hopefully, set precedents for future NDIA decisions. And the stakes here are high. Program clients described a range of supports that they'd been able to access following their NDIS appeals that were life-changing, in some cases life-saving. Legal support was considered vital to achieving such outcomes. Where legal support could be provided early enough, it was also seen to help with good outcomes without always having to go to hearing. There were some key elements that were considered fundamental to the program's success, and a consistent message was the unique specialist skills required by lawyers working on the program, and skill sets included technical legal skills, trauma-informed practice, communication, and relationship building. Disability advocacy organisations and legal aid lawyers noted the importance of clearly delineated parameters regarding legal and advocacy roles, and mechanisms such as networking and information sharing were really important there. Ultimately, it was found that there is nothing equivalent. If this program were to cease tomorrow, it would leave a really substantial gap. But, of course, there are always things that can be done better. And when we asked about challenges, you will not be surprised by the words about to come out of my mouth. It was funding, 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 and funding. It was considered important in order to provide legal support to as many people as possible, to meet need and demand, and to retain a skilled workforce. The short-term nature of funding agreements has made it difficult for legal aid commissions to appoint staff on permanent contracts, and that's contributed to high staff turnover. There were also concerns about fulfilling commitments to clients, in examples where the client's appeal would extend beyond the end date of the funding agreement. Well, this might sound like stating the obvious. As independent researchers, we went into this evaluation without assumptions, and we were very clear from the outset that if we found the program wasn't working, then that's what we would report. But based on the evidence that we considered in this evaluation, we've found that there are substantial benefits and that the program plays a unique function in contributing to a fair and efficient appeals process, particularly for people with disability. It's much needed. Some of the things that could be done to improve the program in terms of design, structure and delivery, of course, funding should be ongoing, not based on short-term agreements as has been the case, and it should be increased to meet that need. Tailored and targeted efforts are required to engage and identify as a starting point some of those groups of people who are missing out on the program. And that really requires close collaboration between legal aid, NDIA, disability advocates, Aboriginal community-controlled organisations, and organisations led by people with disability. The impacts of the program have been appraised here via the best available data. But, as I mentioned, there are limitations to our findings due to the lack of consistent national data. Shared data collection and reporting mechanisms are really needed across all states and territories to be able to tell the full story of the impact of this program. And finally, I'd like to just offer some reflections on what we've learned about the appeals process more generally and access to justice for people with disability via this process. And ultimately, transparent and consistent decision making from the very start of a person's NDIS journey is really key to reducing pressure on the whole system. If the NDIA draws on precedents and fulfils its model litigant requirements, if the tribunal is able to enact its aims of accessibility and fairness, if skilled advocates and lawyers are available to support people, and if the strengths of people with disability are centred throughout the whole process, then we will get much closer to a just system. So thank you so much for your interest in this piece of work, and I'm really excited to hear from our panel and the insights that are about to be shared. And again, thanks to everyone who contributed to this meaningful piece of work. Thanks.
Thank you, Kate. That was a really terrific presentation. And also thank you for your great research. It makes the case for greater legal services so strongly, I think. I'd also just like to take the opportunity to acknowledge the work of the National Legal Aid team, Catherine McKernan and Fei Zhang, in managing this project. And I'd like to acknowledge the strong contribution from the National Legal Aid NDIS Working Group, which provided advice on the draft report and gave interviews to provide insight into the program. So I thank you sincerely for your enthusiasm and your hard work and your support for the project. So now I would like to introduce our panel. I'd like to introduce Catherine McKernan, Executive Director of National Legal Aid, Miles Brown, Managing Lawyer of Victoria Legal Aid's Economic and Social Rights Program, and Melanie Schlager, who is a person with disability who provided input into the evaluation. The panel is here to discuss their experience of the NDIS Appeals Program, and now I think I'm handing to Catherine.
Thanks so much, Toby. So this is just going to be a bit of an informal chat with some experts who have experienced or worked within the NDIS Appeals Program. So hopefully just to illustrate what was a very excellent presentation in terms of what the evaluation found. So Melanie, we might just start with you. Do you want to just tell the audience a little bit just about your experience and the roles you've played within the sector too? We mentioned that you were part of the advisory committee for the evaluation, but you have many other hats. I just thought you might want to tell your story a bit.
Yes, thank you, Catherine. Oops, it's turned on. Thank you, Catherine. As you mentioned, I have personal and professional experience when it comes to this process. So I work now on the advisory committee for the strategic planning of the NDIS. But personally, I many years ago worked before NDIS came into being. I worked with lots of families around planning and goal setting when it came to NDIS planning meetings and things. So I suppose you could say I thought that I had it nailed personally when it came around to navigating things for myself. But I learnt through this process that certainly wasn't the case.
So Melanie, do you want to just talk through a little bit about what your experience was when you went through the NDIS appeals process? Feel free to just share what you're willing to, but just your reflections on it.
Sure. So I think I was going through the appeals process for approximately a year before I accessed legal aid support. So I was using just purely disability advocacy supports, but then pretty much the appeal wasn't going anywhere, and we're going around in circles. I think I don't want to think about how much sleep I lost during that process. I probably aged 5 or 10 years, and it just it made me think about rather than how I contribute to the community as a person and as an individual without disability, it made me think about how my disability impacts me and what it costs the world and the NDIS, which is, as you can imagine, not a nice thought. So when I was able to access the legal aid program, first of all, the lawyer was really good at explaining to me what sort of evidence we needed and how to frame that, which I think is the key. And she also saw the value in getting professionals that were already involved in my life so that they could give evidence that was relevant to my case, rather than using an independent assessor, for example.
Great. So it helped a great deal in terms of, and did it sped the process up too? Is that what happened?
Yes, I would say I'd say from start to finish with the legal aid representation took probably another 3 months, and then we I was also part of the independent expert review program, which was with also the support of the legal aid lawyer to help advocate for me if needed. But what I found during that process was that I actually didn't need that much involvement, even though she was a part of it with me, because the independent expert review program was much more personable. And so I guess my lawyer could then just focus on the technicalities rather than fighting the NDIA so much.
Great. And so what do you think, in terms of your experience, what reflections do you have in terms of how the program could be improved or how the system could be improved in terms of for people with disability trying to navigate the appeals process?
Look, I could run a whole seminar on that, I feel, but we'd all go home next week. So I think that first and foremost, what could be done is that the panel could, particularly from the NDIA's side, they could give some opinion about evidence in between conferences, because what we found was that we'd be all prepared and we'd spend months and such anticipation collecting this evidence and working really hard on the evidence and have many meetings with your lawyer and things, and you get it all ready, and then they'd pick up on one bit, and so you'd be in the conference for 20 minutes and they'd go, oh, you need to come back to us with X, more information about X. And it was so frustrating because it'd be something that you could have incorporated perhaps, you know. So I think that could be something that's improved. Also, I think just earlier involvement of legal aid, if NDIA is going to maintain such a legal base, because as much as they say, and you mentioned, Kate, that they try and make it accessible for everyone, even if you don't have representation. That wasn't my experience, and I would say that I'm a fairly switched on individual who knows what she needs and the impact of when I don't have it.
Great. Is there anything else you'd like to mention, Melanie?
Only just to, I guess, reiterate what Kate said in terms of that is such an important program, because when we're talking about funding for this program, it's not just about basic needs. It's about whether you're facilitating or denying someone's life. And I think that is the key that the NDIS and NDIA don't often think about in terms of that. And I think that's what the lawyer, in my experience, brought to my attention, because, you know, you get quite battle weary, I suppose. But she would say to me, you know, you deserve what you're asking for. You're not asking for something that's unreasonable. And I think when you don't have that representation, you kind of lose sight of that sometimes, because that's just how it goes when you constantly have to justify it.
Great, thank you. That was really powerful, Melanie. Thank you so much. Miles, I'm going to switch to you, if that's okay. You've been working with the NDIS Appeals Program since its inception, and one of the kind of real experts, I would say, across the legal aids in terms of your knowledge and experience. I'm just going to ask you, what are the things that you're most proud of in terms of the work that you've done within the NDIS Appeals Program?
I mean, I guess, firstly, I want to reflect back. So when the NDIS first came in, there was a trickle of referrals through directly from the department until we had our own system for assessing against the criteria that we talked about. And in the early days, the focus really was on complex or novel matters. And so I guess at the starting, as the scheme first begun, there was two, cases that Victoria Legal Aid ran, but really our clients were the kind of people who saw what the scheme promised. So Liam McGarrigle, who was a young man who relied on taxis to get into town and do activities, and was told by the agency that it wasn't reasonable for them to have to pay the full cost of the taxi because his parents could afford to contribute to that. And that case, and he established the principle that really if you're going to fund a disability support, it needs to be fully funded. And very early on, we also had Kylie McCutcheon, a mother who was seeking disability support for her, as she was finding herself more and more dependent on her wheelchair to provide care for her child and get out with her child. And there was a whole dispute around whether chiropractic care could be funded. And in that case, she really talked about how chiropractic care helped her, and really and it was a crucial way in terms of lived experience, and how her experience really trumped what the reports were saying. So I guess, seeing the scheme evolve in those really early decisions was probably, I felt very fortunate to see what those clients were able to achieve. I think in terms of what I'm proud of, and it's really something I'm more proud of my team, it's just in 2020, 2021, we saw such a huge shift in numbers of matters at the tribunal, so from 2,000 to 6,000 in 1 year. And it meant we had to make really difficult decisions around who we assisted, and that kind of percolated over the next couple of years as we kind of had to redesign our services. And what it means is that our team now has to kind of really work with people in a very difficult situation to target a limited resource and try to ensure that we can provide advice clinics when we can, that we can represent people that needed, and those are always really difficult decisions, and they often feel quite cruel because, as we know, everybody, and as we've heard, is going to benefit from legal assistance with these matters. So, I mean, I wish we didn't have to have that response, but the way in which I see my team have it to deliver that every day is, I'm just really proud of the work we're doing with those limited resources, but it's really not enough.
And do you have any thoughts just on the work that the program has done in terms of helping set sort of the parameters and support, as you've mentioned the 2 cases that were early, but just in terms of setting the parameters and what should be funded? Do you have any reflections on that?
I mean, I think that there are some, people who work in the area, there's some really crucial cases that our clients have fought for that have created outcomes. But one of the real challenges with NDIS practice and is that a lot of it just comes down to the evidence. So no matter all of the work we do, and I think this has been your experiences as well, you can see the principles, but you're still being told you have to rush around and get all this detailed evidence, which has become more and more expensive. As you were saying, they shift the goalposts all the time. Yeah. So yes, I think we and our clients have done really valuable work in kind of setting up how the scheme should operate, but I still find that we're in the trenches all of the time.
And around the trenches, what are some of the challenges that you're facing now in particular, but also throughout the time that you've worked with the program? What do you think some of the key challenges have been?
Yeah, so our team also works in social security law, and so we often appear at the same tribunal with the Department of Social Services instructing, and they just take a completely different approach in terms of their lawyers. They're collaborative, it's working to kind of what are the criteria we're trying to meet? That evidence would help, and it's kind of an ongoing, evolving discussion around whether a person will meet the criteria for what they're entitled to or not. And then you compare that with the approach of the agency and their private law firms. It is so hard for our staff and for our clients it really just feels like a combat. I mean, obviously it's an adversarial system, but they really make it as difficult as possible. They shift the goalposts. We are being forced to contest issues that have been conceded. We are grappling with huge evidence costs. We're being told we have to bring 8-10 witnesses to hearing. That's 3 or 4 days of hearing. And then, as we know, not everyone's got legal representation. So people are grappling with all of that without even a lawyer to assist them. So all of those features have actually got worse over the last few years. So other issues, of course, are the funding issue. We can't build expertise if we don't have ongoing funding. It's an area of law where it's incredibly complex. The other challenges, sorry, I'm just going to quickly look at my notes. I mentioned the cost of reports. We've got a new tribunal which has been kind of promoted as being responsive to diverse needs of parties, but really seems so far to us to be very fixated on efficiency. And so we would really love to be engaging with the tribunal around how we can best work with our clients to get outcomes, but we're not seeing that engagement from a new tribunal. The other primary issue that we're dealing with is demand. So I was looking at the figures because I'm on the NDIS Dispute Resolution Working Group. The latest figures for last year for the tribunal, and this is the whole of last financial year, is 7,381 matters. So the highest prior that kind of caused panic stations for us was 6,000. We're tracking well above that, and that's almost double what it was last year. So the demand pressure is not abating, it's increasing, and again, that's a huge challenge for us because it means we're having to make all of those difficult decisions in a more difficult environment. So not to be grim.
So quite a few challenges, yeah. But nonetheless, I think we've heard today just how important and impactful the work is, and yeah, so that's great. We've got some time for questions, so if anyone has any questions online or in the audience, feel free. Do you want Faye? Yep. Whoa. Thanks, Faye. All right, I'm seeing myself as I look at these. The question is, While legal services may technically be available, we know for many people with disability, especially those with cognitive, psychosocial or communication support needs, the complexity of the NDIS appeals process can still exclude them in practice. What steps are being taken to address this kind of potential indirect discrimination and to ensure that accessibility isn't just about being available, but about ensuring systems are accessible? That's a very that's a question that's hard to answer, but does anyone want to have a go?
From my perspective, the legal aid program that I was a part of made it more accessible, because that is, I guess it bridges the gap between NDIA legal speak and kind of smoothing that out for you. But I was saying earlier today that unfortunately it's often about like knowing how to get help, and I think maybe it's some more work needs to be done around that, to make people more aware of how to get help. But then it's a tricky balance, because we've heard this afternoon on the panel that there's such a high demand for that help. So I guess what we really need to focus on is how do we balance that. And I guess I could say I'm lucky personally because my disability is purely physical. I do have friends who have intellectual disability and psychosocial disability who I know struggle with that, and I know that I have found myself in informal advocacy positions for them. So it is an area of the system that I'm aware of needs to change.
Thanks, Melanie. Do you want to say anything too, Mars?
Yeah, I agree with all that, and I also just wanted to note that I guess it was that point about the tribunal's responsibilities and the objective of being responsive to the diverse needs of parties. And I mean, I think there's going to be a role for us to make them accountable, but I would like to see them really take seriously their obligations to ensure that the tribunal is accessible and people can participate in the tribunal. So I think that's work for all of us, but obviously it's real work for the tribunal. Yeah.
And that leads to another question from the Zoom, which is, what changes do we need to see from the ART to better support those people?
Well, I mean, as a start, I think they should be taking responsibility for those obligations, and I guess I'm just disappointed to see that there's not practice directions really, or a real focus on this. And I know the tribunal's new, but I'm just not seeing the discussions happen in the tribunal space around how to progress that work.
From my perspective, I think I would like to see some health professionals, relevant health professionals on the panel to, I guess, kind of complement the NDIA legal side, because, and definitely ones that are specific to the case, which I know would be a lot of work for them, but I think it could actually shorten matters and make things more understandable, because if you're purely coming from a legal angle, you spend a lot of time justifying.
I should mention too that CLCs also provide legal assistance for people with disability, but yeah, the evaluation is focused on the legal aid work, absolutely, but I do want to acknowledge that CLCs also deliver this work. There were some questions from the audience. Sam?
I'm just going to add one more thing, because it's not really for me to tell the tribunal how to do that job, but there are people who can, and the tribunal really should be consulting with people with lived experience around how to make itself accessible, and it should have meeting, like a proper system for engaging with people so that they can feel sure that they're making their tribunal accessible. So hopefully that's something they can take on board at some point.
Hi, I'm Sam from Victoria Legal Aid. Melanie, thank you so much. I just feel like having your voice and your experience is just incredibly powerful, because I think it really resonates around the importance of all of us working together on a better system. I was really interested in your reflections on the independent expert review, because going to some of the points that's been raised about the challenges and the kind of overly legalistic approach, but also the complexity of it, your reflections seem to really be that that process was much more person-centred, and that you felt like you were able to navigate that with obviously a lawyer assisting, but that you were at the centre of that in a different way. So I was interested, I guess, to unpack that a little more, because I think that there are real opportunities, I guess, earlier to think about other sort of dispute resolution, and that was certainly one that seemed to be really positive generally.
Yeah, absolutely. I think it's important to say that at that point, when I got up to independent expert review, I already had a lot of evidence, and we'd been through a lot. So I suppose the independent expert reviewer had a lot of evidence and a lot of bedtime reading to do before we had a conversation with him. But what I really noted throughout that process was that it was a respectful conversation. It was the only conversation in the almost 2 years that I didn't cry after a tribunal. And I think I remember the lawyer only saying one or two things to kind of add to or put it in terms that, like, something that maybe I'd missed, but he was just asking me questions about, you know, what sort of things I needed help on it, and I felt like he was listening. And then he actually, at the end of the conversation, he actually apologised, and he said, "I'm sorry that you've been going through this for the last 2+ years. You should have all of the funding that you have been asking for, and I will be recommending that, and you should have a good sleep tonight." And I think it's terrible that it gets to that point for people, because I'm aware that I can speak for myself, and I know how to get help, and I know a lot of people in professional context who can help me when I need certain kinds of help, because I know what I need. So I worry about the rest of the population, because if I found it so hard, and then I can only imagine how other people who have less intellect or other challenges would find it. Because if you asked me to sum it up into one word, it would be that it was harrowing. And it is something that I still recover from today. I'm much better than I was, but like it's I would never go and work for the NDIS because of what I went through. And don't get me wrong, I'm very happy that I have the funding that I need, but I could never work for them, because if ever I had to deny someone something, I don't think I could do it.
Hi. Sort of speaking on behalf of some of the appeals advocates. I mean, the legal support is a great service, and the evaluation is a great thing, but given that advocacy is funded around about the same amount as the legal support, and handles about 10 times the clients, and produces the same benefits, and has a nationally consistent data capture, it seems like an opportunity missed not including that in the evaluation, given the totality of the system and supports around appeals. Is there any rationale for that?
Yeah, I can. It's actually limited funding from our end. So we got a bargain deal from the National Law and Justice Foundation to do this work, and so we only had limited resources ourselves. And we had been engaging with DSS at the time, now DOH, around potentially doing a program evaluation, but
they were, for whatever reason, unable to do that. So we took the initiative to do this component. But the answer is yes, just limited resources from our end. I think it would be, they are reviewing the whole program this year. So I would hope that we absolutely acknowledge the great work that disability advocates do much more broadly, and the large number of clients that you see as well. I think it's really important to look at the whole program, and hopefully that's what will happen this year as they review all of our funding. Yep. I think that's probably time.
Thank you. So my sincere thanks on behalf of everyone to the panel. Catherine, thank you for facilitating. Miles, we're very lucky here at Victoria Legal Aid to have your expertise, and thank you to you and to the team as well for the ongoing and really substantial contribution you've made. To Melanie, thank you so much for your incredible advocacy. It's been a real privilege, I feel, in being the recipient of your generosity and sharing your experience with us today, and for the work that you've contributed to this really important research. So sincere thanks to you, Melanie, for that. And again, just to Dr. Kate Davies as well, thank you very much to you and the team, and thank you for your presentation. So in closing, I just want to thank on behalf of National Legal Aid and all legal aid commissions. I want to say a really big thanks to everyone for your ongoing support, but also for your continuing interest in this work. So thank you to the people who are here at 570 Burke Street, Melbourne. Thank you to everyone who is online. And apologies, you've got a side view, but that's where the cameras are. But thank you very much for attending. Opportunistically, I just wanted to encourage people to consider attending the Access to Justice Conference, which is being held here in Melbourne at the end of October. It's running from the 29th to the 31st of October. Among other things, it's going to be looking at the work of the legal assistance sector, also in the context of the ART, so we can keep the conversation going more broadly, that is. So yeah, thank you again. Thanks for being part of the discussion and for the questions, and that's it from us, and have a good afternoon and the rest of the week. So thank you.